Welcome to today's webinar. My name is Scott Kester. I have been training people for their trucking compliance for over 31 years. I have been with Registration LLC for the past 7 years. If you have any questions, please post them in the comments and I will answer them towards the end of this presentation, or you can always call the office Monday through Friday and ask for me. Okay, let's not waste any time and get straight into it. What to do when the FMCSA audits you. We'll explore the various audits and compliance reviews you might face and offer guidance on steering your way through the process, from your initial contact with a DOT officer through preparation to the final report and subsequent actions. First, let's define what an audit entails and who performs it. Your audit may be conducted by a federal DOT officer or a state agency working under contract with the federal DOT. These audits assess a motor carrier's safety fitness in operating commercial motor vehicles. They focus exclusively on safety-related matters that impact your ability to operate safely on highways and do not cover IFTA, IRP, or OSHA-related issues. These audits evaluate numerous DOT requirements, including safety management controls, operational performance, and compliance with U.S. regulations regarding hours of service, vehicle maintenance and inspection, driver qualification files, drug and alcohol testing, commercial driver's license standards, financial responsibility, accidents, and hazardous materials if applicable. Let's start with the new entrant safety audit. This can be an in-person audit by a DOT officer or a document upload review on the FMCSA website, where you will upload your documentation online. The audit checks for established records and processes and generally occurs around the 12th month of operation, since a carrier is considered a new entrant up to their 18th month. This audit evaluates 7 fundamental factors to gauge safety regulation compliance and help set up a robust safety program. The cornerstone of compliance is documentation. Even if you adhere to all regulations, failing to document your compliance means you may not pass the new entrant safety audit. For instance, if you're unable to provide documentation, such as pre-employment drug test results, to a DOT officer, it could lead to a failing audit result. For companies beyond the new entrant audit period, whether they have undergone an audit or not, the term compliance review, also known as a DOT or FMCSA audit, may be familiar. There are several types of compliance reviews, including the on-site focused review and the off-site focused review. The DOT typically conducts a focused review when one of your basic scores exceeds the threshold. During a targeted examination, the Department of Transportation DOT auditor will focus exclusively on the particular areas flagged by CSA as surpassing the established limits and possibly contributing to your crash rate. Whether it's an off-site or on-site targeted audit, your company won't receive a safety rating. However, significant non-compliance might result in a classification of unreadable and potential fines. A key difference between on-site and off-site audits is in document submission. Off-site audits require the motor carrier to send all necessary files to the auditor. If these documents aren't provided within the auditor's specified time frame, the off-site audit may be escalated to an on-site audit. In an on-site review, the auditor will visit your facility and select the files they wish to inspect. Conversely, during an off-site review, you're able to choose which compliant files to submit to the auditor. The final type of audit, and our primary focus today, is a comprehensive investigation or compliance review. Various triggers can prompt a company to undergo a compliance review. These include the 7 basic factors, which stand for behavior analysis and safety improvement categories: unsafe driving, crash indicator, hours of service, vehicle maintenance, controlled substance and alcohol, driver fitness, and the hazardous materials indicator for companies that transport hazardous materials. Several reasons may prompt a compliance review: an uptick in violations during roadside inspections, accidents, customer complaints, and a rising CSA score. Increasing CSA scores particularly may put you on the radar for a compliance review. The FMCSA aims to audit every motor carrier once every 2 to 5 years, though this goal isn't always met. However, even companies with no apparent compliance issues could be subject to a compliance review. Once selected, the auditor generally contacts you either by phone or email. In my experience with the DOT conducting compliance reviews, I typically started with a phone call using the number on file. If unsuccessful, I'd follow up with an email. It's crucial to respond promptly if an auditor reaches out, as FMCSA protocols will be followed strictly. Ignoring these contacts could lead to a notice or demand letter outlining what's needed and the response timeframe. Failure to respond to these requests puts your company at risk of fines and possible suspension of your operating authority. Once contact is made, the auditor generally aims to schedule a mutually convenient meeting, typically set for 1 week to a month later. To streamline the auditing process, they typically contacted motor carriers 2 weeks to a month in advance, offering a selection of weeks for them to choose from for scheduling. This approach ensured a smoother process and guaranteed that someone from the carrier would be available during the audit. It's important to note that the Department of Transportation, DOT, is only required to give a 48-hour notice for record preparation before an audit. Although they often provide more time to help you get ready, the minimum notice is 48 hours. There are instances where the DOT might not notify you in advance, such as in the event of a serious accident, a complaint against the company, or a special audit. They can conduct an unannounced compliance review, often without prior notice. While rare, I have encountered this a handful of times, usually involving federal DOT officers. In the case of severe crashes, they will likely want to review your records immediately. Despite its rarity, it's crucial to be aware that this can happen. Once the DOT has contacted you and scheduled the compliance review, they will give you a list of items and information they need. Typically, the DOT inspector will send a few pages of questions covering the basics of your company's operations. They will request a current list of drivers and vehicles your company has operated in the past 12 months, which you should complete and return promptly to the DOT officer. The compliance review will encompass all safety-related areas. The DOT will require access to all relevant files or records, though they will review only a sample of each. They should begin with a brief discussion outlining what the compliance review entails, identifying areas of focus, and addressing any questions or concerns from the motor carrier. If your company had personnel responsible for specific files or areas, and they were available, the officer could request to speak with them to understand their procedures and get their perspectives, starting with driver qualification files, then reviewing hours of service, examining drug and alcohol records, checking vehicle maintenance files, and finally reviewing insurance and accident information. After collecting all the necessary information, they will return to their office to compile a final report before revisiting the motor carrier to conclude the compliance review. The process should begin with driver qualification files using a specific table system. For instance, if a company employed 1 to 5 drivers, the DOT would sample all driver files. For 6 to 25 drivers, they would review 5 files. And for 26 to 50 drivers, they would inspect 8, with the number increasing proportionally for larger fleets. You must make all driver records accessible, allowing the DOT officer to decide which ones to examine. Drivers who need to maintain a DOT-regulated file include those operating any commercial vehicle with a GVWR or actual weight exceeding 10,000 pounds, whichever is higher. Be cautious with vehicles that weigh slightly under 10,000 pounds, as they can surpass this limit once loaded. If a vehicle alone is under 10,000 pounds yet, in combination with a trailer, exceeds this threshold, it qualifies as a commercial motor vehicle. The FMCSA provides a detailed list of required elements for the driver file. Additional documents may be necessary for drivers operating vehicles over 26,000 pounds or those requiring a CDL. I've seen companies maintain files only for CDLs and not their other drivers, resulting in multiple compliance violations because they lack documentation for non-CDL drivers who operated vehicles between 10,000 and 26,000 pounds. Investigators typically start by reviewing files for red flag drivers, those with significant infractions like driving under the influence, driving without a CDL, or using an incorrect CDL for the equipment operated. Motor carriers need to be vigilant about these violations, since FMCSA investigators scrutinize them during audits. These are the first files they review. This scrutiny is also crucial when hiring new drivers. The FMCSA closely watches companies employing drivers with red flag histories. Employing such drivers can trigger a compliance review or draw more attention from the FMCSA. After reviewing red flag drivers, DOT officers will inspect files for drivers involved in accidents over the past year. They will also check newly hired drivers within the last 12 months to ensure robust hiring practices. If further review is required, they will randomly select drivers from the remaining pool. In addition, DOT officers will assess record of duty status documentation. They sample logbooks similarly to driver qualification files, with a 6-month retention period for logs. For a first compliance review, officers will examine 1 month of logs free of charge to the driver, and for subsequent reviews, they will inspect 2 months of logbooks or time cards. They will also request all supporting documents, such as bills of lading, load tickets, and receipts for fuel, food, lodging, and repairs. A note about supporting documents. The items listed are not exhaustive. Any documents related to operating a commercial motor vehicle must be provided to the auditor upon request. Failing to provide this documentation is treated similarly to submitting a falsified log. If an auditor determines you withheld supporting documents, it will be recorded as a violation. Motor carriers often withheld crucial supporting documents because these receipts or papers would expose falsified logs or hours of service violations. Sometimes, they don't even realize how important these documents were. It's vital to understand that all receipts or documents related to vehicle operation serve as supporting evidence. A conditional rating can pose significant problems for a motor carrier during a DOT audit. In an audit process, the officer could match the trip pack with the logbook and receipts. If a trip pack showed a fuel stop or tollway travel, or a logbook mentioned a bill of lading number, those documents needed to be present. Missing these supporting documents could lead to monetary penalties and negatively impact the company's compliance review rating. Another critical area the DOT examines is drug and alcohol testing records. Motor carriers must provide drug and alcohol policies to all drivers and ensure all heavyweight truck or CDL drivers are part of a random testing pool. You will need documentation showing which drivers are in this pool and pre-employment test results for each driver. The DOT auditor will cross-check your current driver list with those in the testing pool. It's important not to include drivers who are either unqualified drivers or drivers no longer employed in the pool. You might have heard about diluting the pool. Including drivers who shouldn't be there dilutes the pool and reduces everyone's chance of being selected. Ensure that all necessary drivers are indeed in the consortium testing result pool. Additionally, having a robust process for random drug and alcohol tests is crucial. Your designated employee representative, DER, should understand the procedures, and drivers must know that once selected for a random test, they need to promptly report for testing. There has been confusion when motor carriers notify drivers about random tests, especially if drivers are far from testing facilities. Some carriers allow drivers to return to their base location first, which could take several days or even a week. This practice is incorrect. Notify drivers of their selection only when they are at a location where they can immediately go for testing. Another significant aspect of drug and alcohol testing is reasonable suspicion testing. Ensure all driver supervisors have completed reasonable suspicion training. This training educates supervisors on detecting potential driver impairment or intoxication and outlines the necessary steps to take if such situations arise. One crucial aspect that can influence a company's score during a compliance review is vehicle maintenance. Through my experience with compliance reviews, I found that complying with vehicle maintenance requirements is relatively straightforward, yet it frequently gets overlooked, or companies may be unaware of what is needed. Vehicle maintenance mainly involves 5 key components. Firstly, every commercial motor vehicle should undergo an annual inspection. This is a common area of non-compliance, but it's easily managed if the company has a system to monitor when maintenance or inspections are due. DOT auditor will examine the dates of the last inspection or the previous few inspections. Should it have been more than a year, or there were gaps between inspections, leading to vehicle operation without passing these, a violation will be issued for not completing periodic inspections. According to Part 396.3 of the Federal Motor Carrier Safety Regulations, carriers must have a systematic program to inspect, repair, and maintain all motor vehicles or intermodal equipment under their control. This applies to any vehicle over 10,000 pounds. All power units and trailers must be inspected annually by a certified inspector. It is crucial to ensure there are no periods where inspections are missed. If there is a gap, the vehicle must not be operated during that interval. You should keep a copy of the annual inspection within the vehicle and another in the maintenance file at your office or the location where you store your records. Next, implementing a preventive maintenance schedule is essential. Your company needs to establish this schedule, and a good starting point can be the original equipment manufacturer, OEM. Most OEMs provide an inspection and preventive maintenance timetable for the vehicles they produce. These timetables include recommended intervals based on miles, hours of operation, or dates, along with checklists of items to be inspected. There are several ways to manage this schedule. In some reviews, shops sometimes used a dry erase board with a corner legend indicating the tasks involved in Type A, Type B, or Type C maintenance. Alternatively, some companies outline their maintenance schedule within their maintenance policy, specifying when each level of maintenance will be conducted. Others might use color-coded Excel spreadsheets that highlight when maintenance is due based on mileage inputs. Although there's no single mandated approach for tracking this, having a written and documented system is vital. Ensure that maintenance is performed and recorded accordingly. Additionally, maintaining a log for random repairs is necessary. This record should detail all repairs made to the vehicle. For instance, if a truck suffers a tire blowout on the road or a headlight fails during a trip and the driver gets repairs done at a garage or buys parts, there should be a receipt and an entry should be made in the log, noting the repair date. The final components of the maintenance section in a compliance review involve the Driver Vehicle Inspection Report, DVIR, and DOT roadside inspections. Recent changes by the FMCSA mean DVIRs are only required for recording safety-related defects rather than daily reporting. Once a defect is identified, it must be documented on a DVIR and repaired before the vehicle can return to service. This repair should be entered into the random repair log along with an invoice showing the issue was resolved. Similarly, your company should retain copies of all roadside inspections conducted by DOT certified officers if inspections reveal violations but do not warrant putting the vehicle out of service. The driver can continue, but the violations must be addressed before the next dispatch. For out-of-service violations, the repairs must be completed before the vehicle leaves the inspection site. The mechanic responsible for repairs must sign the inspection report. If the driver performs the repairs, they can sign, indicating their title as driver and date it. For third-party repairs, the mechanic must sign, certifying that the out-of-service violations have been resolved and the vehicle is roadworthy. The DOT official should inform the driver about the specific timelines for each required repair. The vehicle must not be operated if either the vehicle or the driver has been placed out of service by the DOT officer. I once observed a situation where a driver who had been placed out of service decided to drive his truck away from the scale. The California State Police were informed and they apprehended him roughly 20 miles down the road. The driver was cited with a mandatory court appearance, arrested, and jailed. Speaking with the trooper, he explained that he arrested the driver and took him to jail because the driver had already ignored the out-of-service order once. The trooper believed he couldn't trust the driver not to do it again and did not have the time to monitor the vehicle to ensure it remained out of service. As a result, the company will also face a fine during its next compliance review for operating a vehicle in an out-of-service condition. After the repairs are completed on the vehicles, an entry should be made on the random maintenance schedule, accompanied by a receipt for the repairs and a copy of the inspection report in the vehicle maintenance file. Routine roadside truck inspections could result in a conditional or unsatisfactory rating. If the out-of-service rate exceeds 34%, the motor carrier will receive an unsatisfactory rating. The DOT officer has a similar table related to driver files to determine how many commercial motor vehicles CMVs will be inspected. If fewer than 34% of the inspected vehicles are out of service, you will receive a satisfactory rating. If over 34% are out of service, the rating will be unsatisfactory in the vehicle maintenance category. During the meeting, the DOT officer will also inquire about any reportable accidents in the past 12 months. According to the FMCSA, a reportable accident is defined by one of the following. 1. Was there a fatality? Any fatality always makes it a reportable accident. 2. Did anyone sustain bodily injury that required immediate medical treatment away from the accident scene? If so, it's considered a reportable accident. 3. Did any vehicle incur disabling damage requiring it to be transported from the scene by a tow truck or another means? For example, one company thought they had a reportable accident, but the tow truck simply hooked the vehicle and pulled it back onto the road, after which it drove away under its own power. This is not considered a reportable accident. The vehicle must be removed from the scene by a tow truck or other means to qualify as reportable. In the event of a reportable accident, maintaining an accident register is necessary, detailing basic information such as time, date, location, involved parties, and whether there were fatalities or injuries. Alongside the accident register, copies of state-required accident reports and insurance documents must be kept. The DOT officer will also need to see the MCS 90 form from your insurance company, which indicates your company's financial responsibility. Generally, an interstate motor carrier not hauling hazardous materials must have $750,000 in liability, while a hazmat carrier needs $1 million. This summary highlights what the DOT officer will require during a compliance review. As the initial meeting of a compliance review concludes, the officer typically asks if they can take the hours of service documentation back to their office. This part of the review is often the most time-consuming, and examining the hours of service documentation at their office can save the motor carrier the considerable time it would take to review all the hours of service records, which might take several hours or more, depending on the number of drivers. After reviewing all file information, the auditor will likely return to their office, examine the hours of service documents, and compile their final report. This report will summarize the company's operations. Part A will encapsulate your operations, while Part B will list violations found along with recommendations to address these issues. The report will also reference 6 factors impacting your overall rating. Factor 1, financial responsibility, insurance, and general provisions, including accident registers and various regulations. Part 387 and Part 390. Factor 2, drug and alcohol testing requirements, CDL standards, and driver qualifications. Factor 3, driving CMVs and hours of service violations. Factor 4, vehicle-related violations and maintenance. Factor 5, recordable accident rate. Factor 6, hazardous materials violations. The accident rate factor comes into play only if the motor carrier has experienced 2 or more recordable accidents in the past year. Based on this rate, the rating can be either satisfactory or unsatisfactory. A satisfactory rating is awarded for an accident rate of 1.5 or lower, whereas an accident rate higher than 1.5 results in an unsatisfactory rating. The FMCSA determines your company's performance in Factor 6 using the following formula: the number of recordable accidents multiplied by 1 million, divided by the total miles driven over the past year. For instance, if your company recorded 4 accidents in the last 12 months and drove 2.5 million miles during that period, you would have a crash rating of 1.6, leading to an unsatisfactory evaluation in the crash factor. Ratings for factors 1 through 5 depend on the number of acute or critical violations in each category. FMCSA considers an acute violation as severe, necessitating immediate correction, such as knowingly allowing a disqualified driver to operate a vehicle. A critical violation indicates a repeated pattern of infractions, like falsified logs. Auditors look for recurring issues in the company's records. Exceeding 10% of false logs triggers a critical violation. Each factor is rated as follows: satisfactory, no acute or critical violations detected; conditional, 1 acute or critical violation found; unsatisfactory, 2 or more acute or critical violations identified. The outcome of the compliance review will be one of 3 overall ratings: satisfactory, conditional, or unsatisfactory. This rating is based on the total points accumulated across all factors. A table provided by the FMCSA illustrates how the overall rating is determined during a compliance review. Each acute or critical violation typically scores 1 point, except for Factor 3. Violations related to hours of service, whether critical or acute, count double. adding 2 points due to the higher crash risk associated with these infractions. The left columns of the table show the number of unsatisfactory and conditional ratings across different factors, while the right column provides the final overall rating. For example, if there are no unsatisfactory ratings, but more than 2 factors with a conditional rating, the overall rating will be conditional. As mentioned earlier, the result will be one of 3 ratings. A satisfactory rating is the most favorable and implies that FMCSA has determined the company maintains adequate safety management controls and strives to comply with federal regulations comprehensively. A conditional safety rating indicates that while the FMCSA has identified at least one violation of federal requirements, the company is not deemed an immediate safety threat. Companies with this rating won't receive an out-of-service order, but might face financial penalties. Their operations could be affected negatively, as contractors and insurance firms may hesitate to engage with them. To upgrade from a conditional rating, a company must demonstrate corrective measures by submitting a corrective action plan, CAP letter. An unsatisfactory rating is more severe, highlighting significant violations or non-compliance that could lead to safety hazards. Alongside financial penalties, companies have 60 days for property carriers or 45 days for passenger and hazmat carriers to submit a corrective action plan. It's crucial to note that FMCSA regulations allow the federal DOT 45 days to review your CAP letter, effectively giving you only 15 days to ensure it's reviewed within the given period. Failure to submit the CAP letter within the time frame can result in the suspension of the company's authority. Motor carriers with an unsatisfactory rating are barred from interstate commerce operations. To maintain operational status, submitting the CAP letter promptly is essential. The letter must provide evidence of safety management controls that improve compliance with FMCSA regulations. Depending on the specific violations, proof of training might be necessary. For instance, if there are significant hours of service violations, you should train your drivers accordingly and possibly have a third-party audit logs for compliance. Your company's final FMCSA report will identify safety management breakdowns across 5 areas: policies and procedures, roles and responsibilities, training and communication, monitoring and tracking, and meaningful actions. The CAP letter should assign responsibility for these breakdowns and offer proof of implemented or improved processes. The final report might also mean fines for various violations based on their nature, circumstances, extent, and gravity. For example, documentation violations can result in daily fines of $1,544 up to $15,445, while falsifying logs can incur fines up to $15,445. Operating outside FMCSA regulations can be costly, with fines and the potential damage to your company's reputation. Settlement cases are public and can impact your ability to attract qualified drivers and maintain a positive brand image. Compliance should be viewed as a crucial business cost, whether through hiring compliance staff internally or engaging third-party services. Maintaining compliance can prevent costly legal issues from accidents caused by non-compliance. Any violations can sometimes be challenged, but you must prove the inaccuracy of the auditor's findings. Make sure to review your compliance report thoroughly to ensure that all violations are accurate. Now is the time to ask your questions in the comments. Or if you need help with any of these products, you're more than welcome to give us a call at 866-477-0707. We are open Monday through Friday from 9 a.m. to 8 p.m. Eastern Standard Time, from 6 a.m. to 5 p.m. West Coast Time.